Hi, everyone. Let's see. Let's see who's here, who's not. Please share so that others will join. Happy New Year to you all, and a very good evening from Virginia. I hope you're all doing well. Please share so that others will join. Happy New Year. And let's see. Please feel free to share so that others will join. So exciting to be here today. Let's see if TikTok is working. Please let me know if you can hear me. Let me enable the comment feature. Please let me know if you can hear me. Let me know if you can see me. And please share so that others will join. Happy New Year to you all. I hope you had a wonderful break. Oh, I did. I'm hoping you did too. Okay. So Happy New Year. Please share. Please share. Hashtag immigrants brave. How is immigration treating all of you? I'm trying to join TikTok, but please share so that others will join. Feel free to put in your comments, your questions. I'll take a few questions. Let me try to join TikTok from my phone. But I hope you're all doing well. How was the Christmas break? For those that celebrate Christmas like me, how was the Christmas break? How was the festive season for you? I had an amazing time. I hope you did as well. Where's TikTok? Where's TikTok? If you can hear me, please let me know. If you can see me, please let me know that you can hear me. Let me know that you can see me. We are discussing visa overstay and adjustment of status as well. That's what we are discussing today, hot topic. So please share so that others will join. I was tricked into doing this, but it's always nice to be here and to share a few things as far as hot topics are concerned. So today we're doing visa overstay and adjustment of status. But if you have any questions, please feel free to type it in the comments box so that I would answer them. But please share, invite your friends, mistakenly share to your enemies as well. So we're doing visa overstay and adjustment of status, which happens to be a very hot topic under the immigration climate we find ourselves. And if you are Ghanaian, I'm sure you know it's a very, very buzzing topic at this point. So please share so that others will join. I'm trying to join TikTok from this gadget here. So please pardon me, but we are going to start in a minute. Immigrants brave, hashtag immigrants brave. Invite others to join. Tell them we are here to discuss a very important topic here. Visa overstay and adjustment of status. Please share, and invite others to join. Okay. Let's go live on TikTok. I hope you're doing well. Happy New Year. How was the festive season? How is immigration treating you? What's new as far as your immigration status is concerned? If you have any questions, please type it in. Type it in so that I answer them before I discuss my topic for the day. Visa overstay and adjustment of status. It's a hot topic now that we are discussing today. So please share so that others will join in. Okay, and we are live on TikTok. That's where all the fun is. I think Instagram and YouTube and Facebook are a bit bougie, but the fun is always on TikTok. So let's share. I am sharing. Please share so that others will join as well. I'm sharing this to my Facebook so that others will join. So please share, please share. All right. All right, so we will be discussing visa overstay and adjustment of status, but Hey, TikTok, I hope you're doing well. Invite others to join. Hashtag Immigrant Brave. I'm so excited to be here and to be doing live stream again. It's been a long minute, but I'm excited to be back. So please share so that others will join. And let me know if you can hear me. Please let me know if you can hear me so that we proceed from there. Please let me know if you can hear me. Let me know if you can see me, right? Okay. Oh, hi. Oh, I'm doing well. I hope you're doing good too. Thanks for asking. I see some of my clients here. I was struggling into doing this, but it's exciting to be here. Please share, please share, please share so that others will join. We are discussing visa overstay and adjustment of status, which is everyone's favorite. Adjustment of status is what gives you the green card in the United States. So I know it's everyone's favorite. And at some point in time, immigrants would overstay their visa. And so what do you do when you overstay your visa? Is there any way you can prevent visa overstay? How do you even know that you have overstayed your visa? What documents do you need to check whether you have overstayed your visa? How do you know the timeline? How do you know when you are supposed to exit the country when you enter into the United States? So we are discussing that visa overstay. Now, when you overstay your visa, are you even able to get a green card? Would you be able to apply for an adjustment of status? And if you do apply for an adjustment of status after you have overstayed your visa, are there any repercussions? Are there any consequences to overstaying your visa? These are the things we'll be talking about. So please share. Please share. I know as immigrants, at some point, you overstay your visa. The strategy most immigrants use is to come in on a B1, B2, and then adjust their status. So this is a very good topic. It's a hot topic that we are discussing. So please share so that others will join in as well. All right, let's see who is here on TikTok, and I will take a few comments on Facebook before we start. All right, do I have any of my assistants here? Please let me know. Put in our booking link, put in our phone numbers, our inquiry email, so that if anyone has any questions, they can shoot us an email. But it's really nice to be here. Please let me know where you're watching me from. Let me know where you're watching me from. Okay, someone says they're in New Jersey. Someone is watching from New York on TikTok. Oh, okay. Someone says they're watching from Sunyani. Nice. Thank you for joining all the way from Sunyani on TikTok. Thank you. I do appreciate that. Thank you. Someone says they're watching from Italy. Okay. Okay. Hi, Akosia Williams. I hope you're doing well. Good to see you. Please share. I know you have a huge following, so please share so that others will join. But thank you. Oh, you're watching from ATL. And my sister is also watching from Ghana. Sister Bex, I hope you're doing well. Please share so that others will join. We're talking about visa overstay and adjustment of status. It's a hot topic. Now, beyond how hot it is now, I know that as immigrants, you come in, at some point you adjust your status. And before you do, most of the time you overstay your visa. So we are discussing overstay your visa and adjust your status in the first place. Are there any repercussions for overstaying your visa? And if there is, what do you do? Is there any category of the basis of adjustments that would preclude you from any repercussions? Those are the things we are discussing. So please let me know where you're watching me from. Let's see TikTok. Okay, someone is watching from Accra, Ghana. I have my sister also watching from Ghana on Facebook, which is great. Okay, hey, so when you say this name, it means you really know me. Someone is mentioning a certain name here on TikTok. You probably attended school with me, but you have a certain username that I cannot recognize. So I hope you're doing well, whoever you are. Thank you for joining. Thank you for joining. Okay, New York. I see New York. California. Nice. Thank you for joining. Florida. Oh, nice. So many people. If I miss you, please pardon me. But please share. Please share so that others will join. Please share so others will join. There's another Accra, Ghana, Arizona, Utah. Oh, nice. I've lived in Utah before. So thank you for joining. I know Utah very well. I've lived in Utah before. Someone says the Bronx. Yes, I've lived in the Bronx before. Grand Concourse, that's where I used to live. So I've lived there before. There's New Jersey again. Okay. Oh, I see another Atlanta here on TikTok. Let's see. Someone says you're watching from Togo. Thank you for watching from Togo. Thank you. I don't know the time in Togo now, but thank you for watching all the way from Togo. There's another Arizona. Oh, thank you so much for joining. So we are discussing visa overstay and adjustment of status and how it comes together. All right. So what is a visa overstay? When we say someone has overstayed their visa, what does that mean? So a visa overstay is when a non-US citizen remains in the country beyond the period of authorized stay. So when you enter into the country beyond and remain here beyond your authorized stay, you have overstayed your visa. How do you even determine the duration of time that you have here? There's a document called the I-94. That is what you have to check. So the form I-94 is the arrival departure record. It's an official US immigration record issued by the CBP, and that shows you when you enter the United States, your immigration status and how long you are authorized to stay here. Now, depending on when you enter the United States, your I-94 would either be paper or electronic. I had the paper I-94, and that's been a very, very, very long time. But now is an electronic version. And so that document would help you know how long you're authorized to stay. Now, you can have an expired visa and still be in valid status. That is something that confuses most people. Classic example. So you sometimes you get the multiple entry, 5 years visa, right? And you enter the United States on that multiple visa, and the CBP allows you 6 months, which you find. Now you know that you can find that on your I-94. And so irrespective of the fact that you have multiple visa, you are not authorized to be in the United States for the duration, for that 5 years. It is only your I-94 that determines how long you can be here. And so you can have an expired visa, but still remain in legal status or valid status. You can also have a valid visa, but be out of status. Okay, you can have a valid visa but be out of status. And so it's important to keep an eye on your I-94. There are two possible notations as far as the I-94 is concerned. You either have a specific date from when you are supposed to exit the country, or you have a DS, the duration of status. So for the duration of status, it's very common for the J1, the students, J1, F1 and M1 students. So for the I-94 duration of status, you remain in status as long as you comply with the terms of your program. And so if you're here on F1 and your school is 1 year and you're able to do OPT, let's say you're able to do OPT for 1 more year, but before your OPT, the duration of your program school is 1 year. That is the duration of your status. So if you're an F1 student, a J1 exchange program, M1, you're looking at your duration of stay, duration of status, I beg your pardon, and that is the time within which your program ends. Now, if you do OPT, then it continues, right? So it's either you have a specific date on your I-94, or you have a duration of status, which is the DS. That will give you the time within which you must remain in the United States. Now, there are times that you enter the US, immigrants will enter the US on a B1, B2, and then you file to change your status or to extend your stay in the United States. That is a possibility. Now, you file for the change of status or the extended status in the United States with the USCIS. Classic example, You come in, you're given, let's say 4 months, not the regular 6 months, but you're given 4 months of stay on your I-94 to remain here. And then you file for an extension. The USCIS, upon approval, would issue the approval notice, which is the form I-797, and that will come with a new I-94. And so that becomes the controlling record. You're no longer looking at the initial I-94 that you received, but you will now be working with the new one that the USCIS issued to you after approval. All right, so keep that in mind. The new, your new I-94 is the receipt that the USCIS has granted, which will come with a new I-94. That is if you come in to change or extend your stay in the United States. Now, you overstay your visa if you remain past the I-94 expiration date, or you violate the terms of your status. Classic example. For those that come in on a B1, B2, you're not authorized to work. You're not authorized to work. And so if you violate the terms of your visa, right? So you engage in unauthorized employment, even if you have a duration of stay, that is a problem. All right, that is a problem. And if your I-94 expires and you're still here, and prior to expiration, you don't file for any change of status, or you don't file for an extension, you have overstayed your visa, right? Now, what are some common ways that people accidentally, it happens, overstay? Latter part of last year, we had a client who said that they didn't even know what the I-94 was. They didn't know how long they were authorized to stay here. Now, the lack of knowledge may not necessarily be accident, but the person didn't know. And so by the time they contacted us, they had overstayed their visa. Now, when you overstay your visa, depending on the timeline, it can trigger a bar, right? It can trigger a bar from re-entry. And so you want to be mindful. But what are some of the common ways people accidentally overstay? Assuming that the visa expiration dates are control stay. No, I've seen this multiple times. You meet people who are supremely intelligent, and they say things like, oh, because I had a multiple visa, I thought that my 5 years visa authorizes me to stay here. No. It is your I-94 that determines how long you can remain here. There are those that simply misplace the I-94, right? So many years ago, like I said, the I-94 used to be paper. When I entered the United States the first time, my I-94 was a paper. It wasn't the electronic one. Now they're being fancy, which is good. And so if you misplace your I-94 and you don't have the date, then of course it's a way where you're likely to overstay your visa just because you didn't know. For students, school termination or serious violation. So if for some reasons your school terminates your admission, then you have no business being here if you do not change your status or you don't adjust. And so school termination and service violation is also a common way that causes visa overstay. Now, there are people who don't understand the grace period. So I want to explain what a grace period is. So a grace period is a limited window of time that allows certain non-immigrants to remain here or prepare to depart the United States. For people on immigrants on the F1, the J1, the M1, H1B, O visa, there's always a grace period. Now, when people confuse the timeline, you're likely to overstay your visa. And so I'll give you some of the common visa status. Okay, what's happening on Facebook? I think we went off. Are we back on? I think we're back on. Let me check. Are we back on Facebook? I think we got disconnected. Are we back on Facebook? Okay, we're back. I believe we are back on Facebook. Yes, we are. All right. So grace period for common status. For F1 students, your grace period is only 60 days, right? So the 60 days after program completion. So you come into the United States and then you get a duration of stay, or you come in, that is on the F1, or you come in on a B1, B2, and then you change your status from the B1, B2 to F1. And so your prior I-94, that probably gave you about 6 months or 4 months or whatever timeline that the CBP gives you, will change from the initial I-94 to what the USCIS is going to issue when they approve your change of status. Now, you're likely to get a duration of status. And so at the end of your program, that's it. You have 60 days at the end of, after your program ends, to be here or to be prepared, to prepare to depart the United States. So your grace period as an F1 student is 60 days. I think sometime December 21st, someone reached out to us here, a student, and at the time she had called, she had actually exhausted the 60-day grace period. She said that she didn't know. She didn't even know what it meant by getting the duration of status, the DS, in the I-94. That's number one. It's important that if you don't understand or you don't know, please ask. Don't assume and don't listen to people. I can't say that enough. I don't even want to get into that yet. So for F1 students, you have 60-day grace period after program completion. Now, if you do OPT, so after school, you enroll in OPT, as soon as your OPT ends, 60 days, that's it. At that point, after 60 days, on the 61st day, you are accruing unlawful presence in the United States, and that can be a problem. For J1 exchange visitors, your grace period is only 30 days. You have only 30 days to be here. Now, for those that enter the United States on a B1, B2, you have no grace period at all. And so if the CBP issues an I-94 for 6 months, I highly recommend that you don't leave around that time. Leave before the expiration of your I-94. I know too many people who have left the country in their 5th month or their 4th month, and when they were entering into the United States, again, the USCIS says that no. I mean, the CBP says no. So they were deported at the airport. All right. So please be mindful that the fact that your I-94 states 6 months, you don't necessarily have to be here for 6 months. My recommendation will be that you exit the country maybe in your 4th month. Even the 5th month is a bit tricky. Remember that the CBP exercises discretion, the same with the USCIS. And so if they decide to exercise discretion, they can choose not to let you enter the United States. So B1, B2, no grace period at all. Right. So your grace period does not extend lawful status. Let me explain that a bit. So if you're on F1 and your duration of status ends and you have your 60-day grace period, that grace period does not extend lawful status. Once it's done, it's done. Once you exhaust the 60 days, that's it. Now, once grace period ends, unlawful presence begin immediately. And so if you have 60 days on a J1 and you wait till the 61st day, you have accrued unlawful presence on the 61st day. And so once grace period ends, unlawful presence begin immediately. Now, depending on your visa status, overstaying your visa can void your visa. So if you do have a multiple visa, 5 years, and you overstayed, and I've seen this, just on the 30th of December, just last month, a musician in Ghana reached out, and his issue was simple. When he came into the United States earlier last year, I mean, not only did he come to work, he was on a B1, B2, but engaged in unauthorized employment by, having shows, gigs here and there. And he actually stayed for 5 months and 2 weeks. And he had a multiple visa. When he exited the country back to Ghana, he received notice of the revocation of his visa. And so your visa can be voided. Please have that at the back of your mind. Number two, overstaying your visa can trigger a 3-year or 10-year ban, depending on how long you stay, and it can prevent adjustment of status as well. Now, many people overstay visa because they assume the grace period protects them. It does not protect you. So once you exhaust your grace period, or within that grace period, the law basically requires you to have a plan. And so are you going to exit the country, or are you going to file an adjustment of status, or are you going to file an extension, or are you going to change your status? That is what the grace period does. And don't wait until your grace period kicks in to plan on what your next steps is going to be. It's not a smart move. Make sure that you have a game plan before the grace period. And please remember that B1, B2, tourist visa, no grace period at all. All right. Now, what are some of the consequences or repercussions of visa overstay? So if you overstay your visa for more than 180 days but less than 1 year, that can trigger a 3-year bar if you leave the United States. And if you overstay your visa for a year or more, that can trigger a 10-year bar from re-entry if you leave the United States. That means that if you overstay your visa for that long, you must have a game plan. You must have a strategy. Because if you don't and you exit the country, and I'm not even kidding about this example, I was informed that on Monday, someone called the office and the person says that their I-94 expires on Wednesday. And this man entered the United States with his wife and 3 children. I mean, how do you put your whole family in jeopardy like that? And his plan is he does not intend to exit the country, but he doesn't even have a strategy. He doesn't know how he's going to adjust his status. He's not ready to exit the country. He actually bought a one-way ticket from Ghana with his whole family. And so he's calling the office on Monday. His I-94 expires on Wednesday. Please have a strategy. Make sure you have a plan when you're entering the United States. Make sure you know exactly what you want to do in terms of adjusting your status. Please. What are some of the other repercussions beyond the ban? You can lose eligibility for certain immigration benefits. And if you even overcome the bar, chances are you would never, ever, ever get a visa again. I know someone currently, a client of mine, and well, let's say potential clients, because I have said to her that representing her will be taking her money when I know that she's not going to get a visa. So she entered the United States years ago, tried to adjust her status, and it didn't work out. She did marriage-based. She started with employment-based, the EB1. Once she received a denial, she put herself on the dating market, got married to a U.S. citizen, filed for her adjustment of status, and she received a denial. And around this time, she has accrued unlawful presence. We'll talk about adjustment of status in a bit. She had accrued unlawful presence without any pending petition, and she got fed up, packed up, and left the country. And since then, she has tried to re-enter, get a visa back into the United States for 8 years, and the consular is not issuing her visa. And so when you stay for that long here in the United States and you eventually exit, when you overstay your visa and then you pack up out of frustration and exit the country, please remember that even if you are issued a bar 3 years, after the 3 years, there's no guarantee that you will be allowed to enter the United States. So have that at the back of your mind, all right? Now, how do you avoid visa overstay? Please be proactive. I cannot say this enough. Be proactive. Long before you decide to leave your home country to the United States, make sure you have a plan. Make sure that you know what you want to do as far as remaining here is concerned. Now, if you do not plan to remain here, or you don't have the intent to remain here when you enter the United States, don't form that intent when you enter based on everything you see or experience here. Because without that plan, without a strategy, you're going to overstay your visa, and that can trigger a whole lot. Everyone knows what is happening. If you're Ghanaian at this point, finance minister overstayed his visa. He has a pending adjustment of status, but that didn't preclude him from being detained. We're going to be discussing that in a minute. I mean, the adjustment of status after you've overstayed your visa. But that didn't preclude him from being detained. Now, I said to someone yesterday, we don't know the full facts of the case, but chances are he probably will be issued a notice to appear that would trigger removal. Does he stand a chance? It depends on the basis of the adjustment of status. If he did an employment-based, forget it. If he did the EB5 gold card, that's something completely different. If he did a marriage-based green card, he has a chance, right? If the basis of his adjustment of status is marriage-based, he has a chance. But if it is not marriage-based and if it's something else, there will be lots of waivers to file. If it is marriage-based, if the basis of his adjustment of status is marriage-based, overstay does not necessarily affect him unless there was suspicion of fraud or misrepresentation. And so it's a lot, okay? It's a lot. So please be proactive. If you don't want to overstay your visa, be proactive. Make sure that you have a game plan before you enter the United States. All right, so I'll take some questions before I get into how adjustment of status fits into visa overstay. The basis of adjustment of status that can help you when you overstay your visa and those that cannot help you. As you know, there's the marriage-based, there's employment-based, there's asylum as well, which I don't know if that is a route former finance minister is going to go. I don't know, but that is also another basis. So I'll take some questions and then we'll get into that. Oh, someone says I'm watching you from New Jersey. Thank you all for the compliments. I'm not going to read any of them, but thank you. I do appreciate that a lot. Okay, I see a few questions. I'll take them. All right, can a green card holder file for his or her spouse? Listen, a green card holder can file for his or her spouse, but the wait time is long. It's going to take a very long time. You have to wait for what we call the priority date to become current. If you are a green card holder, my recommendation will be that you wait to become a U.S. citizen. If you're a U.S. citizen, it's very easy to file for your spouse and you can file concurrently, meaning that you can file your I-130, your I-485, your work authorization, you can file everything together. That is one of the benefits when you are a U.S. citizen and you're petitioning for your spouse. But as a green card holder, if you overstay your visa, and you get married to a green card holder, you probably will be deported at some point because you would accrue unlawful presence for so long that I don't recommend that. Please, if you're looking to file for your spouse and you are a green card holder, take your time, become a U.S. citizen, and then go ahead to file for your spouse. It is faster that way. All right, 𝗧cie, how are you? I'm doing well. I'm doing very well. Thank you. I'm doing very well. Please ask legal questions so that I will answer them. Okay, someone says, if you are in removal proceedings, can you adjust? Yeah, it depends. Did you have a pending adjustment of status before you were placed in removal? I have a client, and I believe it was just before Christmas, we submitted her adjustment of status. So amazing case. This lady entered the United States, got married, the petition got denied, she got married, she put herself on the dating market, and she fell in love with a U.S. citizen. She filed for her marriage-based green card. It got denied, and she was placed, just before she was placed in removal proceedings, before she received the notice to appear. That marriage didn't work, so she filed a divorce, and she fell in love with a U.S. citizen, and this is rare. So for her initial petition, USCIS issued a denial and said that they suspected immigration fraud. She immediately divorced her previous spouse and got married to another U.S. citizen. Now, right after the marriage, USCIS issued a notice to appear. And so at this point, the case is no longer, it has changed jurisdiction, right? From the USCIS to the immigration court. And so the immigration judge is the one supposed to make a decision. In court, we told the judge that, oh, she's married, we have the marriage certificate, so the judge should allow us file for the I-130 and adjustment of status. That is to say that even though she was in removal proceedings, we were able to file the adjustment of status, but it all depends on the facts of the case. There's no one-size-fits-all approach when it comes to immigration. I almost said with removal proceedings, no, but there's no one-size-fits-all approach when it comes to immigration. And so please don't listen to someone's results and assume that yours is going to go the same way. It doesn't work that way. Depending on how you enter the United States, how long you have been here, the things you have done, who you got married to, depending on the facts of the case, the result is always different. So there's no one-size-fits-all approach when it comes to immigration. I hope I've answered your question. Okay, someone is asking a question that is, I think your question is so long. It would be nice if you summarized your question so I can read it and answer it. Okay, so someone says, what happens if you are detained but have work authorization? Work authorization does not confer immigration status. All right, and so the fact that you have work authorization does not mean that you cannot be detained or you cannot be deported. Even with a pending petition, pending adjustment of status, you can be detained and you can be deported. So work authorization does not confer on you an immigration status. And a pending I-130 or adjustment of status does not confer an immigration status. You don't have a status just because you have a pending petition. You don't have a status just because you have a pending petition. So yes, you can be removed. Yes, you can be removed. Okay. Okay, so someone says that, is it safe for a green card holder to travel outside the country? If it's absolutely necessary that you travel, please do. If it's not, please don't. The immigration climate is really hot. And so I don't recommend that you just travel. So please be mindful, all right? Any new immigration judges in San Francisco? I don't know. I'm sorry. I don't know, all right? Okay, all right, so let's move to how adjustment of status fits into visa overstay. What is an adjustment of status in the first place, right? So adjustment of status is the process of applying for a green card from within the United States. You cannot adjust your status from abroad. You have to be physically present here to adjust your status. If you're abroad, then you're doing consular processing. So adjustment of status is the process of applying for green card in the United States. Now, can someone who has overstayed their visa adjust their status? It depends on the basis of the adjustment. It's not a yes or no answer. It all depends on the basis. Now, basis number one, if you're married to a US citizen, you will be able to adjust your status even if you have overstayed your visa. All right. So immediate relatives of a US citizen may still be able to adjust their status even after overstaying their visa. Now, overstay and unauthorized employment may be forgiven if you're married to a US citizen. All right. So if the basis of your adjustment of status is marriage-based, marriage to a US citizen, of course, you may be able to adjust your status. Now, I'm using may because if you have criminal records, if you've been married before and there was marriage fraud detection, that changes everything. But generally, if you overstay your visa and you put yourself on the dating market and you get married to a US citizen, irrespective of the fact that you have overstayed your visa, you will be able to adjust your status. And the same is true if your US parent files for you. So if you come in, you overstay your visa, and an immediate relative, a US citizen immediate relative, is able to petition for you. So I said marriage-based visa, but also other immediate US citizen relatives can also file for you. In instances like that, you can be able to adjust your status, even if you overstay your visa. All right. Basis number 2, employment-based and other categories. Now, overstay can bar adjustments of status for employment-based. Remember, marriage-based is different. Employment-based, you're likely to get a bar as far as the adjustment of status is concerned. And many employment-based applicants must maintain lawful status. Classic example. If you enter the US on a B1, B2, and you say, oh, I know about the EB2 NIW. I want to file for the EB2 NIW. Meanwhile, your entry is just 6 months. By the time, even if you do premium processing, if you contract an attorney, you retain me to file for an employment-based petition for you, the EB2 NIW. I'll come to the EB1. The EB2 NIW, and you're here on a B1, B2, and you have only 6 months to remain here in the United States. Now, if you even retain me to do premium processing, to file for the petition using premium processing, and you receive a decision within 15 days, at most 45 days, by the time your priority date becomes current, when you can actually adjust your status, you would have accrued unlawful presence for so long that alone can bar you. Now, there are waivers that you can file, but it's extremely difficult to get an approval of a waiver. And so as far as employment-based is concerned in other categories, overstay can bar adjustment of status. And so if you're filing for an adjustment of status through employment-based, it's important that you maintain lawful status. All right. Now, overstay based on employment-based may require that you do consular processing. You heard me say you either adjust your status when you're able to adjust your status when you're physically present here, but you do consular processing when you're abroad. So if you're adjusting your status through employment-based, you come in on a B1, B2, a temporary visa, it's always better to do consular processing and not an adjustment of status, because you would have overstayed your visa by then. All right. So adjustment of status can be strategic. It helps. All right. It helps. Now, it allows for work authorization and travel permission while your case is pending. Generally, when you have a pending petition, a pending adjustment of status, you cannot travel outside the United States. However, because of that pending petition, you can apply for travel permits so that you exit the country and come back in. Do I recommend that under this current administration? I do not. Adjustment of status, again, can be strategic because it may stop accrual of unlawful presence. Again, if you're married to a U.S. citizen, yes, you've overstayed your visa, and you're married to a U.S. citizen, it may stop accrual of unlawful presence. All right. All right. So before I came in here, someone sent a question, and I think that's the answer to this question would probably sum up everything, number one, and number two, for those that are following the detention story of the what's his name, 𝗧cie𝗶𝗰. This will probably give you an answer to that. Now, we don't have the full facts of his case. We only know bits and pieces. I think today I read somewhere that some of the lawyers are not even, his lawyers in Ghana are saying things that they don't know. So we don't know the full facts. But this will probably be a very good scenario and a very good answer to the little that we know. Now, the question the person sent to me is that, is it possible to be detained or placed in removal proceeding if you have overstayed your visa and have a pending I-485? I'll be answering that question shortly. Let me see if there are other questions here to answer before I answer this question, and we'll be out of here in a few. Okay, can a person win an appeal? Yes, you can win an appeal depending on the facts of the case. All right. All right. How long does adjustment of status take? It depends. It depends. We have filed adjustment of status where we have received approvals and green cards have been mailed to us in 4 months. I also have clients whose petition have been pending for the last 2 years. So it all depends. It all depends. It all depends. All right. Okay. So let me answer this question. Is it possible to be detained or placed in removal proceedings if you have overstayed your visa and have a pending petition? Yes, it's legally possible to be detained or placed in removal proceedings if you have overstayed your visa and you have a pending petition. It is legally possible. However, in many cases, the 𝗧cie𝗽𝗶𝗰 and ICE exercise lots of discretion, right? And the existence of a properly filed and bona fide adjustment application can provide strong protection, although it is not an absolute shield. So if, let's say you're put in removal proceedings, even though you have a pending adjustment of status, the fact that you have a pending adjustment of status can help you in immigration court. However, it's not an absolute shield, all right? So generally, overstay creates removability. So under the INA, that's the Immigration Nationality Act, I believe it's section 237A1B. It says that a person who overstays their authorized period here in the United States becomes out of status. Being out of status makes you removable. So irrespective of whether you have a pending petition or not, the fact that you have overstayed your visa makes you removable, period. All right. Now, a pending petition, like I said before, does not confer an immigration status. It doesn't. So the fact that you have a pending petition does not mean you're a green card holder. It's just pending. It's just what it is. It's pending. It doesn't confer any status on you. It does not give you immigration status. It does not automatically stop ICE from initiating removal proceedings. That is to say that you can have a pending adjustment of status, which is the I-485 that will give you the green card, and ICE can still initiate removal proceedings. And it does not guarantee protection from detention. At this point, we know that, right? So a pending I-485, a pending adjustment of status, again, does not confer immigration benefits or immigration status. Number one, it does not automatically stop ICE from initiating removal proceedings, which is deportation. And number three, it does not guarantee protection from detention. It doesn't. What it does is that it provides eligibility for relief. And so if you have a pending petition, that is with the 𝗧cie𝗽𝗶𝗰. Once ICE picks you, put you in detention, and then issue a notice to appear that will trigger removal proceedings, which is the deportation, then 𝗧cie𝗽𝗶𝗰 no longer has jurisdiction. Jurisdiction is now with the immigration court, and it's only the judge that can order removal or order your pending petition be reviewed and a green card be given to you. All right. So once you're placed in removal proceedings, you're detained and you're placed in removal proceedings, you have no business with 𝗧cie𝗽𝗶𝗰s. It is only the immigration court and the immigration judge that would be able to, make any decision on that pending petition. So in summary, a pending adjustment of status does not grant a green card. It does not grant legal status or immigration status. It does not automatically stop ICE from initiating removal proceedings, and it does not guarantee protection from detention. The only thing it does is it makes you eligible for relief. All right, let's see. Do I have anything more in my notes? Yes, I do. Okay, so what usually happens in practice is that 𝗧cie𝗽𝗶𝗰 generally does not refer adjustment applicants for removal solely because they overstayed their visa. I say this all the time. There's always an underlying factor, all the time. all the time. The fact that you have just overstayed your visa is not enough. Solely, there's always an underlying factor. All right. Now, ICE may act if there are criminal issues, there are fraud or misrepresentation, there are prior removal orders, or national security concerns, or long unlawful presence combined with other violation. So the fact that you have overstayed your visa alone, it's not enough. It can trigger removal, but ICE exercise discretion. I guess that's what I'm trying to say. ICE is going to exercise some discretion. Okay. All right. So you may be detained if you have criminal convictions. You enter the United States unlawfully, or you violated your the terms of your visa. All right. Or the suspected fraud. I have a couple of clients who are currently in immigration court. We are in removal proceedings because they got married to U.S. citizens, and 𝗧cie_𝗶𝗰 determined that their marriages were not bona fide; they were fraud, and they were detained. We got bond, we got them out, which is great, but we are in immigration court because 𝗧cie_𝗶𝗰 has issued a notice to appear, and so they are currently in removal proceedings, and that can be tough, especially if in the past your marriages were determined to be fraud. All right. Now, again, can you be placed in removal proceedings with a pending I-485? Absolutely. Absolutely. If ICE issues a notice to appear, which is the NTA, that is a charging document that begins removal proceedings. At that point, like I said, 𝗧cie is going to lose jurisdiction over the I-485, and immigration judge or the immigration court gains authority. All right. So lawful entry plus overstay plus marry to U.S. citizen would allow you adjust your status under INA Section 24A. I'll repeat that. Under the Immigration Nationality Act, Section 245A, if you enter the United States lawfully, meaning that you were admitted, you got a visa, you start on a plane, or you were paroled into the country, and you have overstayed your visa, but you got married to a U.S. citizen, you will be able to adjust your status. All right. All the other bases, that may be tricky. And so have that at the back of your mind. I hope you now understand how visa overstay and adjustment of status come together, and some of the bases that can help you adjust your status. If you get married to a U.S. citizen and you have overstayed your visa, it's a good basis. I'm not saying go and marry U.S. citizens because you have overstayed your visa. That's not what I'm saying. I'm saying that if you overstay your visa and you put yourself on the dating market, you fall in love and you're married to a U.S. citizen, you will be able to adjust your status. All right. So a pending adjustment of status is not immunity from deportation, but it offers a very powerful protection when the case is properly filed and the person is eligible. All right. Overstay alone does not trigger detention. However, it makes you removable under the law. And so have this at the back of your mind, and please have a strategy as you enter the United States. Don't just pack your bags and enter the United States. Have a strategy on how you intend to adjust your status in the United States. All right. All right. So let me see if there are some questions, I'll take them. If there are no questions, we'll call it a day. Someone is asking for our phone number, 703-705-9905. If you're looking for an attorney to help you with your immigration petitions, please give us a call at 703-705-9905. You can send an email to info@ablegalconsults.com, and you can book a consultation on our website, www.ablegalconsults.com/booking. All right. The number again is 703-705-9905. Can overstay person file for marriage? I just answered that. Let me see. All right. So yeah, I see lots of questions here, but I have exhausted my time. If you're looking for an attorney to help you, please, I just put our numbers out there, 703-705-9905. And I see some of my team members typing in our email, which is info@ablegalconsult.com. Please follow our social media pages, AB Legal Consult, across all social media platforms. And I look forward to coming again sometime soon. Have a good night and enjoy your weekend. Thank you for joining. Bye-bye.